Straight ahead on Law and Crime Daily, crazy moves by a watercraft captured on a sheriff's camera.
The hardest thing about this case is solving it.
And the retrial of an Iowa woman in the death of her own infant daughter.
You can't just assume that because somebody confessed that they're guilty.
Plus, a Kentucky state representative arrested while protesting the police killing of Breonna Taylor. Why she says she was targeted.
My daughter and I and the people arrested with us have continued to show up for justice for Breonna Taylor.
Also,
it seeks to acknowledge that there is, in fact, racial bias in our criminal justice system.
new California laws aimed at making the justice system more just. Law and Crime Daily covers court cases from coast to coast. And welcome everybody to Law and Crime Daily. I'm Erin along with Brian Buckmire and Terri Austin. Authorities say they've positively identified a victim of one of the country's most prolific serial killers. Terri Austin explains how investigators cracked this cold case. Terri.
Erin, for 40 years, the family of Patricia Parker had no clue what happened to her. But thanks to tips from the community, the Georgia Bureau of Investigation now has an answer, and it lies with DNA technology. Parker's death is believed to be one of 93 murders committed by Samuel Little. The FBI says Little is linked to murdering women across 19 states for over a quarter of a century. Little has confessed to the murders and drew portraits of his victims from memory, including a woman from Chattanooga, Tennessee. His description matched a 1981 unidentified remains case from Dade County, Georgia. GBI's cold case unit was called to conduct a forensic analysis.
We took the rendering, had it sent to North Texas State to the DNA lab out there. DNA was done. We sent it off to the FBI in Quantico. They did the DNA test there, confirmed that it was Miss Parker. After we had been we were reached out from the family to let us know that they believed it was her. We took DNA samples from the son, sent it off with the bone, and that's where the DNA comparison came up with. Miss Parker was 30 years old when she was killed. She would be 69 years old. She's still alive today. We made contact with the family this morning to let them know she has a son that's still alive here in Chattanooga, to give him that closure and to kind of give him some comfort that his mom didn't abandon him.
Little is currently serving 3 life sentences in California for strangling women.
Kentucky State Representative is speaking out after some, but not all of the criminal charges against her were dropped after she protested the police killing of Breonna Taylor. Attica Scott is still facing misdemeanor charges after protesting and then entering church grounds for sanctuary as a 9 p.m. curfew in her city kicked in. The church had agreed to be used as a sanctuary for protesters. Scott is also the author of a bill in her state which aims to abolish no-knock warrants. Law and Crime's Brian Buckmire spoke with the representative and has her side of the story. Brian?
Representative Scott tells me people have been protesting the death of Breonna Taylor in Louisville for more than 130 days. She says that she was arrested alongside 17 others protesting the grand jury's indictment of only one officer for wanton endangerment.
We were blocked in by a black militarized vehicle in a parking lot that also had another entrance blocked off with a concrete block, so we couldn't get out. So we walked to the church. Just as we were about to cross the street to the church, police stopped us, told us to turn around, then yelled, circle them, wouldn't let us go anywhere, and proceeded to arrest us with their guns in our faces, their pepper ball guns in our faces. And I was shocked. I've never been arrested before. My teenage daughter was with me, so I was very concerned about her safety. I was shocked that they would dare claim that I would try to burn down the library that's in my district, District 41, the district that I serve, that Black people desperately need. So we fought those absurd charges, especially the felony charge, and we're very grateful when those charges were dropped. Because quite frankly, Brett Hankinson, the detective who received a Class D felony, spent 32 minutes in jail. We received a Class D felony and spent 10 hours in jail. Ridiculous.
Representative also says she and her daughter were tear gassed on day 2 of the protest. She believes she was targeted by the police because of her bill to abolish no-knock warrants.
Louisville passed Breonna's Law at the local level. We're expanding that. They ended no-knock warrants locally. Breonna's Law for Kentucky will end no-knock warrants at the state level, but it would also mandate that officers involved in deadly shootings and other violent incidences submit to alcohol and drug testing. And it would mandate that any officer issuing a search warrant must have on their body-worn camera 5 minutes before and 5 minutes after issuing that search warrant. Of course, they wanted to retaliate against me for wanting to hold them accountable. And I'm also suing them for tear gassing me and my child. So of course they wanted to retaliate against me. And I feel like that's what the county attorney is doing right now by only dropping the felony charges and now making us wait until November 16th to face the 2 misdemeanor charges.
So Brian, this was a pretty amazing interview, just hearing from her own sense, her own perspective, what happened. If you were the criminal defense attorney on this case, how would you handle it?
Oh, I would just get ready for trial. I would be laughing at the prosecutors saying, you created a system, maybe not just you, but also Attorney General Cameron, created an environment where the entire city is going to be behind my client. And if you think that a jury of 6 people, because now it's a misdemeanor, are going to find her guilty after protesting the death of Breonna Taylor and the way that this city handled it, just bring discovery. We'll start whenever you want.
Go right ahead, put her in front of a jury, and you're going to assume at least one person is going to say, forget it, acquit, hung jury, something like that. So Terry, how might a judge look at this case if it winds up in front of a judge? Is there even cause to keep moving forward here?
Well, I think the judge is going to look at it the same way a jury would, frankly. And I think the judge is going to say that these protesters, including the representative, were getting into good trouble, like the late Representative John Lewis once said. So chances are that these 2 misdemeanor charges are going to be dropped. I think so anyway.
So, Brian, we're hearing from the prosecutor's office that they dropped the felony, saying, oh, we didn't have enough evidence. Explain that to us. What other evidence would they have needed to go forward with that?
Yeah, so they're looking for writing. They're going to have to show, or they would have to show before dropping that case, or that charge, sorry, that there was some sort of connection between the representative and the 17 others who were arrested who actually either emboldened people to damage that property or damage it themselves. And of course, there's not that connection, so that's why that felony charge dropped, but they still have the unlawful assembly just because they were, as they're accusing him, out past 9.
A case to watch for sure. Brian, thanks a lot for speaking with the representative for us. A nurse who spoke at the Republican National Convention recently is in trouble with the law. Amy Ford claims self-defense after shooting a woman she was arguing with over the weekend. The police chief in Williamson, West Virginia, says Ford shot victim Yonda Witt in the abdomen. Witt had to be airlifted to the hospital, but is expected to survive. Supreme Court nominee Amy Coney Barrett is facing confirmation hearings in the U.S. Capitol. Barrett is President Trump's nominee to succeed Justice Ruth Bader Ginsburg, who died September 18th. The nominee has served as a federal appeals court judge and as a professor, and once was a law clerk for the late Justice Antonin Scalia. The proceedings are scheduled to take 4 days. Key issues are expected to be religion, abortion access, and health care. And still ahead here on Law and Crime Daily, California lawmakers passed sweeping reforms aimed at taking race out of the criminal justice equation, and they could change the way juries are picked. And later on, a mother accused of strangling her daughter with a pair of pajamas gets a second trial. Was it murder or an accident? A Sheriff's Department helicopter catching dramatic video of a boat out of control in Florida. The Sheriff's Department says 3 people were on a photo shoot when they fell overboard and their boat kept on going. The people in the water swam to safety. 1 person had minor injuries, but the Sheriff's Department had to fly over the scene to monitor the situation. The boat eventually slamming into a couple of docks and became slightly airborne for a while before ultimately coming to rest. A second trial is scheduled tomorrow for an Iowa mother accused of killing her 5-year-old daughter by strangling the little girl with a pair of pajamas. A jury acquitted Kelsey Thomas of child endangerment, but was hung on a murder charge. She's chosen to be tried by a judge alone this time around. Firefighters found victim Chloe Thomas dead in her bedroom in July 2018. Thomas told detectives that she put Chloe down for a nap around 1:30 in the afternoon and then took a nap herself. When she awoke, she says she found her daughter dead in a closet and called 911. During the first trial, prosecutors said the defendant confessed to murder and they argued no one else could have killed the child.
There's no evidence of struggle. We know the only people in that house are the defendant, Chloe, and her two-year-old son. When you look at the scene photos and the evidence or the testimony that came to you from the officers and the first responding officers, you heard that there's no vomit in that closet because Chloe was never in that closet. That was the defendant's story when she was trying to come up with something. The pants and the vomit are both on the bed. That's consistent with what the defendant tells you. It corroborates her story. Those pants aren't in the closet, even if you believe her first, second, third version about what happened to those pants. Why would she pick up those pants and put them on the bed? This is somebody, if you believe her story, that walks into this room and sees her daughter hanging there. Even if you believe the pants fell off, why would you then pick up the pants and bring them on the bed? Because that never happened. The pants were on the bed because she dropped them after she strangled her, just like she told you through her confession.
The defense said the confession was coerced and insisted the evidence proves it. They asked the jury to find their client not guilty.
Chloe Chandler was found hanging in her closet, just as Kelsey said. Everything that she did that day, everything that she experienced that day is consistent with that. For all the ways in which the state tries to trip her up, and yes, she ultimately confesses. In every way the state tells her to confess. And I've documented that for you. Sometimes innocent people confess to crimes they didn't commit. This isn't a false confession case because I got an expert to say that it is. Like I said, Dr. Color merely opened your eyes to what I just showed you. You've got a medical examiner who was not confident in her opinion. Even before you heard from Dr. Young, I can't imagine that you had a lot of confidence in her opinion in the first place. If ever there was a false confession case, I could not imagine how it would be supported more than in a case like this.
Okay, so let's jump in for some analysis right now. Terry, what's your assessment of the defendant's choice to be tried by a judge rather than a jury here? The jury was hung the last time. And as criminal defense attorneys like Brian Buckmire might often say, all you need is that one juror to shut down the state's case. If they tried this in front of a jury, they could have another hung jury. The state may have to give up. So why go with a judge?
I couldn't agree with you more, Erin. I mean, most criminal defendants, they're going to take advantage of the Sixth Amendment right to a jury of your peers. And here, for whatever reason, she's deciding to put her fate before the judge. And we know judges are going to apply the law and they're going to be objective. So I think it's the wrong choice, particularly since she did fairly well in front of the jury before.
Yeah, Brian, how would you advise this client? You know, would you say this is a good idea to go with a bench trial this time around?
I mean, me personally, no. I, for example, trust a juror of peers more than I would a single judge. I actually put it in order. It's jury, judge, bears, and then prosecutors in terms of who I trust more. And I wouldn't do this. But if I get a wink and a nod from a judge and it's a technical argument, which I think it might be, then maybe, just maybe, you go with a bench trial.
Yeah, there may be some, one of those little wink and nods here where maybe the defense thinks that the judge might be a little bit favorable to a technical legal argument here. I agree that might happen. So, Brian, how would you defend Kelsey Thomas factually? Would you turn around and say the confession was coerced, she didn't do it?
This wouldn't be a factual argument, again, because it's a judge trial. I'm going to stick to the burden of proof, and I'm going to hold tight to that burden and say these facts don't really add up to what the prosecutor is looking to do. And the best example of that is the previous trial where they acquitted on the lower charge of endangering a child leading up to a death and were hung on the murder charge. That tells me something's fishy here.
We'll watch the trial when it kicks off tomorrow. And still to come here on Law and Crime Daily, a series of bills usher in sweeping criminal justice reform measures for the state of California. We break down the changes with one of the advocates who helped make them happen. A criminal justice group called the Reform Alliance involves big names like Meek Mill, Jay-Z, and even New England Patriots owner Robert Kraft. And it's taking some credit for a series of bills recently signed into law in California. One of the 5 bills says plainly that it seeks to eliminate racial bias from California's criminal justice system. The policy director of the Reform Alliance spoke with me recently and said the legislation was oftentimes based on actual cases where shocking problems were uncovered.
The most powerful examples are always real life examples. As people who work in policy, we can always point to statistics. We can make things abstract, but there is nothing like real life examples, especially told by people who lived through those real life examples. So at Reform Alliance, as well as at several other policy organizations, I think what we found is that really these criminal justice reforms need to be led by people who are themselves directly impacted, who have lived through this injustice, who know what it really means to experience that type of injustice, and who in fact are the best messengers to say to the lawmakers, this is the problem, this is how it manifests, and this is the change that we need to correct it.
The people involved in this reform, you're working with some very famous people on these bills, and some famous voices have been behind them. How important are those voices in the conversation?
I think everybody's voice is honestly incredibly important. We talked a little bit earlier about the importance of having people with direct experiences really lead this movement. For decades now, we've had a lot of publicity around the negative stories around criminal justice reform and sort of law and order. We have, 50 different types of CSI shows. And so we've had many, many people who have really used their platform to help advance kind of fear mongering and stricter, tougher law and order. And so I think one of the things that we're seeing right now is a counter narrative to that. So we have incredible influencers and incredible advocates, people like Kim Kardashian, who doesn't just talk the talk, but really walks the walk and studies all of this. We have incredible advocates like John Legend, like Reform Alliance's board members, Meek Mill, Jay-Z. We just have put together, I think, a really incredible coalition, and their voices have been so, so important, just as people with direct experience have been so important in leading this fight.
And when we come back, a look at what some of the reformers uncovered when pushing for change, and we'll explain changes to the probation system, which will alter the way incarceration rates stack up in the Golden State. New laws in California are aimed to repair what advocates say is a deeply broken criminal justice system. Some of the troubling cases reformers uncovered included a conviction based in part on what the legislation calls an expert's racist testimony that people of Indian descent are predisposed to commit bribery. Another example is that defendants have no recourses if their own attorney harbors racial animus towards the defendant's racial group. And the new laws aim to change existing court precedents that say appellate courts must defer to the rulings of judges who make racially biased comments during jury selection. All of these things happen in real cases cited by the new laws. Reform Alliance Policy Director Erin Haney says one of the new law changes the way defendants serve their sentences.
What we found is that there are so many studies that show that the best amount of time to be under supervision in any state for any offense is actually 18 months or less. Probation is most effective within that period of time. And when you keep people on probation for longer than that, what ends up happening is that you see people going back into prison for technical violations, which are non-crimes. So this could be being late to a meeting with your probation officer, not being able to keep full-time employment, any number of conditions of probation. So by changing something like the amount of time that you are sentenced to probation in California, just from 3 years to 1 year for misdemeanors and from 5 years down to 2 years for felonies, you actually save over 5 years 48,000 plus prison admissions just for technical violations and 24,000 years of freedom. So there will be people who would have been locked inside a prison on technical violations because they had been sentenced to 3 years or 5 years, who will now be free and be able to be productive members of their communities.
How hard was it to convince the governor and the legislature to pass these reforms?
Assemblymember Kamlager was just a force of nature, as was Assemblymember Ash Kalra, Buffy Wicks. There were just so many people who worked incredibly hard to get these reforms passed. Governor Gavin Newsom has been such a great leader in criminal justice in the state of California, and so we owe so much to him. He is managing so many different things, and for him to step up and be this leader on criminal justice reform, especially when we need it the most, was really incredible, and really, I think, gave a lot of advocates so much hope this year.
So, Terry, one of the other new laws changes the way attorneys can strike members of a jury pool. It's illegal in California now as a matter of state statute to use race to strike a member of the jury pool. It's been part of federal case law for a while, but my understanding is this codifies it in California and it changes some of the precise parameters of the procedure.
Yeah, I mean, Governor Newsom has been doing a lot. This is Assembly Bill 3070, and what it would do is limit the removal of prospective jurors without cause. So that actually prevents discrimination based on race and other backgrounds. So it would also shift the burden of proof to the attorney who rejected the juror, and that attorney would have to provide a reason for the exclusion. So you just can't exclude people for any nilly-willy basis.
Brian, do you think the new procedures outlined in California would really help public defenders such as yourself?
I want to say yes, Erin, because I applaud these people for what they've put out there, but the reality is no. I think that this is only half of the picture. I think this is persuasive arguments that you can present to a judge, but unless there are teeth on the back end of that to make this binding upon judges or those who are going to implement these harsh punishments on my clients and others, this isn't going to go far enough.
These laws are pages and pages long. We certainly can continue to dig into them. Thank you very much for joining us here on Law and Crime Daily. Appreciate it very much. We'll see you next time as we discuss justice in America.
Hi, I'm Dan Abrams. In the exploding legal and true crime genre, Law and Crime is the only network that has it all.
Good evening and welcome.
This is a complicated case.
Don't really jump to conclusions.
We break down the case of a serial killer.
Another day of drama between both sides.
From multiple live trials daily to original and compelling programming, the Law and Crime Network is everywhere, and we invite you inside the jury box. This is Law and Crime.